Hey everyone, welcome back to the channel. Today's video is packed, so buckle in. We've got 5 different court hearings to break down, all featuring some classic sovereign citizen courtroom chaos. But we're starting with 3 separate appearances from the living man Eric Martin, a familiar face in Michigan courts. Not only is he juggling multiple traffic citations across the state, but has now added a domestic violence charge to the list. As a result, has been sitting in jail for a little over a month. And these hearings show exactly how that's been going for him. There's a lot to cover, a lot to analyze, and definitely plenty to shake your head at, so let's jump right in.
Okay, in the matter of People versus Eric Martin. Mr. Martin, can you hear us?
Yes, can I get the case number of this so-called case that never was given a copy of the ticket by the police officer, which he should have in violation of my due process right?
241388 SM.
241, what else?
38 SM.
38?
1388 SM.
24138 SM. Right?
Yeah, 2 weeks.
Okay. All right, thank you.
I do have in front of me a complaint charging with domestic violence violation of city code. It's misdemeanor. Oh, I see. January 24th, January 10th. Okay, you pleading not guilty, Mr. Gazicki?
That's John James Gazicki. Mr. Martin expressed his right not to be represented by a court-appointed attorney. He wishes to represent himself.
Okay. Is that right, Mr. Martin?
Present myself, yeah.
Okay.
Because I don't want to give up my right to be one of the sovereign people, as the U.S. Supreme Court said I have right to be. So.
Okay. I'm going to let you do that. I don't care why. Have you talked to the prosecutor?
No, I have not.
I want you to get the prosecutor and have her talk to Mr. Martin, and let's see what we're going to do today.
Right, so I would like to talk to him right about how the case should be dismissed based on there's no evidence.
Well, that's literally what a trial is for, to look at the evidence and let the process play out. And believe me, if there truly wasn't any evidence against you like you keep claiming, we wouldn't even be this far along. We definitely wouldn't have your alleged victim sitting right next to you in court. So he steps into the breakout room to discuss things with the prosecutor. But of course, that goes absolutely nowhere. Why? Because in his mind this is all some grand malicious prosecution, and naturally the prosecutor supposedly has no jurisdiction over him. It's the same tired script every single time.
A matter of People versus Eric Martin.
Okay, thank you.
Mr. Martin, can you hear us?
Yes, I hear you.
Okay, Mr. Prosecutor, want to put your appearance on record?
Hey, good morning, Your Honor. Good afternoon, Your Honor. Omar Shah on behalf of the people, P86-332.
Okay. You've had an opportunity to talk to Mr. Martin?
That is correct, Judge.
Been able to resolve this matter?
Judge, there is no resolution on this matter. I had an opportunity to speak with the defendant in this case. He wishes to have a jury trial or a bench trial. He just doesn't know which one he wants.
Okay, Mr. Martin, which one do you want? I'm going to set this over for a trial. You want a jury or the judge to hear it?
Well, I don't really want to answer that question. I don't want to be fraudulently presumed I'm consenting to any of these proceedings. You know, I'm not consenting to have my right against slavery violated by consenting to any proceedings. So that's why I kind of want to answer that question. But before I get to, as I notified the prosecutor, he should have dismissed the case due to lack of evidence. But I had one more thing I wanted to point out to the prosecutor. I forgot to mention to him. I want to mention to him now, and that is I want the police officer, Bardway, who illegally arrested me. I want him charged for the legal arrest, which is assault and battery. And also Judge Shackelford, who did not give me personal bond. I want arrested too for violating my right against kidnapping and allowing this unlawful incarceration of me, which I have a right to do. And if they refuse to do it, I'm also going to move for dismissal on the case because it's violating my right against equal protection, because I have the right to have charges brought against people who have committed crimes against me also.
He's basically threatening the judge now, saying, go ahead and deny my motion. If you want, I'll just sue you and take your job. Then he claims they muted him like that's part of some grand conspiracy. These judges are apparently about to learn they're not above the Constitution, and according to him, nobody in the courtroom is above accountability, and judging by the way he comments on the judge's robe, he thinks they are the one lacking jurisdiction here anyway. That wraps up the first hearing. Let's move on to the second one and see how much stranger this gets.
Okay, based on that, I'm going to indicate that you want a jury trial. I'll set this matter over. I'll have the assignment clerk set a date. She'll send you a notification of the date for the jury trial. In the meantime, I'm going to continue your bond until that day. You go with the sheriff, he'll take care of you today.
Hello, I have an objection. I have a motion to make that I have a right to a personal bond.
You file that motion in writing, and I'll take a look at it.
I already did file it with the.
In the meantime, I want you to go with the sheriff, and he's going to take care of you.
Hold on, object. I have some. I already
Put 'em
filed it
on,
with the
put 'em on
I'm
mute.
making that motion now. I'm making that demand actually now because it's a constitutional right to be
Alright.
without guilty.
All right.
All right, then I'll be taking your job. How about that? Because you violate my constitutional right, and I move to dismiss you off the case, disqualify you. Since you violate my due process right to a personal bond, then you showed your biasness, and you should not be in the case no more. I move to disqualify you. If you deny that motion, I request that you send it to the State Court Administrative Office. You're not supposed to continue my bond with monetary award. Shackelford illegally denied my personal bond, and you're not supposed to continue that illegal denial. I have a constitutional right to be presumed innocent, and that means the right to a personal bond. Article 3, Section 1, judges that violate the Constitution cannot hold their office. But don't grant that motion if you want to, that demand. I'll be to get your job in a lawsuit. That's all I got to say. So you want to continue with that? Sound like they muted me, maybe. Well, these judges are going to find out. They're not above the Constitution.
Didn't this guy just claim he spent 28 years studying constitutional law, and yet somehow he still hasn't grasped that a jury of your peers means regular citizens, not whatever imaginary group he thinks qualifies as his personal council of advisors? It's amazing how someone can brag about decades of legal expertise and still miss the most basic definition in the entire system.
This is case 231510, people of the city of Taylor versus Eric Martin.
Jeffrey Fanto, the court asked me to verify that Mr. Martin would be presenting himself without the assistance of attorney. That appears to be his position, Judge.
All right, so Mr. Martin, you are waiving the House Counsel.
Yes, so I'm not fraudulently assumed to be the defendant, a living man, not the legal fiction corporate entity defendant, which I couldn't possibly be. I know due to canon law being, unfair, it's gonna, you guys fraudulently assume that if I take an attorney. So that's the unfairness why I can't accept attorney because of that.
Sure. All right, and you understand all of your constitutional rights?
I do my best to. I've been studying, practicing law 28 years.
All right, that's all right. So looks like this is ready to be set for a jury trial. Is that right?
Yeah, but I want a jury trial of my peers means of the sovereign people, not U.S. citizen slaves who most probably everyone of the jury probably say they are. So.
Well, that statement doesn't hold up, at least not the part about why you supposedly didn't know your own bond amount. Now, I can believe you didn't have a dollar to your name because that fits the pattern we've seen from you, but everything else, yeah, that's where the story falls apart. That I covered that hearing. And I have the footage to back it up. Judge Shackelford explicitly told you the bond amount, and the reason behind it, nothing was hidden. The screen only moved after she explained everything. And that only happened because you kept interrupting and turning the hearing into a spectacle. So let's be clear, the confusion wasn't the court's doing. It was your own non-stop outbursts that made the situation harder than it ever needed to be.
As the individual who determines questions of law, that's me. I will make sure that it is a jury of your peers. So, and I'll determine that. So, we will have this set, and then I'll mail out the date for the jury trial.
I believe there's a date set for next Tuesday for the jury trial in this matter.
All right, I see that.
I have objections about, I cannot probably prepare for trial in this jail. I've been illegally denied my constitutional right to a personal bond, even though it's my constitutional right because it's part of my right to be innocent before guilty. It's been denied so far. I have no money to pay for a bond to get out of here. So that's especially why I also should be given a personal bond. And like I said, I cannot probably prepare for one in here, you know?
So you're in there for a different matter, because I set your bond at $100 personal before on this matter. So it's whatever's keeping you in jail isn't this case. So we'll see it. I understand though that you do need to prepare for trial. I get that part. So we'll go ahead and adjourn the jury trial. When is your out date? With whatever you're doing there.
There's no out date. That's the thing. It's So is this about the moped case?
Yeah, this is driving on a. This is
Okay,
driving
so
while your license is suspended.
I wasn't sure. Right, they got me legally confined right now in the domestic violence. No evidence at all. She lied, made a statement. So now they got.
Hold on, Mr. Martin, hold on. Even though this is a different court and that's not my case. You have the right to remain silent. Anything you say can be used against you. I just want to advise you of your Fifth Amendment right again. So I suggest not bringing up the other case. This case here is on the moped and the driving on a suspended license, or a revoked license.
Okay.
So what I'm saying is you need time to prepare on that one. I don't know what the situation or status is of the domestic violence case. But you said that you're on bond. You haven't posted your bond on that case. Is that what you're saying?
Well, I'm not even sure. I think the judge said a monetary bond. I wasn't sure because she unprofessionally drew the thing away from you want to call it this the remote Zoom thing away from the door before I could read the hearer. But it sounded like she told the police officer $2,000, but I'm not even sure. I got no money to pay a bond, no way, but even if it's $1. So.
All right, that wraps up that hearing, but he was back in court again yesterday, and let me tell you, it was something else. I'm not exaggerating when I say he looks like he's aged about 10 years in just 3 weeks. Whatever he's dealing with, it's clearly wearing him down fast, because the difference is honestly shocking.
Judge Shackelford very clearly told you what your bond was and why it was that amount. The screen was only pulled away after your bond was set, and only when you wouldn't stop running your glue eater.
I am allowed. I don't have nowhere else to live. That's my house. I'm allowed there. You ordered
these other individuals.
That violates my due process.
All right. He has a $2,000 cash bond with a GPS tether.
Yes,
and he's not to
my right to a
return.
personal bond.
He's not to appear at
He's
9.
innocent without guilty.
He cannot come to 9074 Clifford or be in contact with Crystal Martin.
So, right, because they illegally deny my personal bond, this is why I'm still in here. So, but yeah. So.
All right. So what I'll do is, I don't know when that case is next. The next day is that it's a state case. Ms. Manarino, you don't have that case, right?
I don't
so it must be a
know.
state. All right, and so it must be a state case, which means it's on a Monday. So that's probably going to be resolved within a month. So let me go ahead and set this for jury trial. No, there will be no need to set it for a settlement conference before that. But let's get a date.
I won't catch up. I was going to object before you guys don't give me a chance to talk. I object to it should be. I moved that to be stayed. This moped case till I get out of prison. Till I get out of jail here. I can prepare myself. I can't probably prepare myself.
Right, that's right. Listen,
to my legal authorities to argue nothing.
It's being set for jury trial.
The one is
From yesterday.
okay. So when is that one?
They didn't set it.
Okay. All right. So I'm going to set it for a jury trial. But if you're still in jail at that time, then I'll just adjourn it again so that you can prepare. I'm not worried about that. So but I can't do anything about your other case, is what I'm saying. So I'm looking at as far as a date right now. I just want to put a date on the books so that we know that you have an idea. If you get out tomorrow, then you'll know and what your date is. So I'm looking at. Let's see. And I don't have the availability to check with my clerk because my criminal clerk is out this week.
Your Honor, we do
So
have other
go ahead.
jury, I'm sorry, Judge. We do have other jury trials scheduled on your docket on July 9th. I don't know if that's too soon.
That's probably going to be, and it's only a couple weeks away. So I don't know what his situation is. And even if he gets out in a week, that only gives him a little bit of time. I want to make sure he has at least a couple weeks to, I mean, it's a driving on a restricted license. So it's not exactly a whole lot of prep time for that. It's not a homicide case, but
It takes a special kind of cell phone to make a legit legal argument and then instantly destroy it in the very same sentence. Yes, it's technically correct that speedy trial protections exist for defendants who are currently locked up and sure under MCR 6.4. C. Omion could be released after 28 days on a personal recognizance bond unless the court has clear and convincing evidence that the person is a flight risk. And here's the problem. Everything about his history screams flight risk. He denies the court's authority. Has skipped multiple hearings, including in this exact courtroom, and he openly acts like future laws won't apply to him. When that's your whole personality, you're basically writing the judge a handbook titled Reasons Not to Let Me Out. SOS. While he tried to quote the rule, the reality is simple. MCR 6.4 C doesn't help him at all. He knocked down his own argument before the judge even needed to respond.
so I'm looking at August 13th, because I'm trying to pick a date that's outside of probably where I'm already scheduling stuff at, because I don't have my criminal clerk here to kind of check and see like where I'm at with things. So we're going to set this for August 13th.
Thank you, Your Honor.
And I know that we'll set that at 8:30 in the morning, August 13th. All right. Mr. Martin, let the deputy know that you're all set, and we'll be mailing out the notice to you, sir.
Thank you, Your Honor. All the best to you and your staff.
I have some more.
Say again?
That's something I want to say to with the prosecutors here. Dealing with this other case that I'm here for now, I request that
Not the same prosecutor. Not the same prosecutor. That's the same prosecutor.
They're Taylor prosecutor.
Your other case, are you talking about your other case? Your other case is a state case, so that's a Wayne County Prosecutor's Office.
No, sir,
Not the city attorney.
I'm talking about
Okay.
the case I'm in here now. I want them to notify the prosecutor that I want charges filed on Crystal Martin for bringing these falsified charges against me now, and also for assault and battery that I have on video camera for. Just so, you know what I mean? And she keeps bringing this.
Again, that's the other prosecutor. That's a different prosecutor's office, sir.
Because it's my equal protection right to bring charges too. They want to bring charges against me, but they don't have no evidence, and I do. And I should be suffering here in jail as a lack of evidence as a result of the unequal protection clause.
And that's on your other case, sir. So,
But it's still a right though. It's still my right to tell the prosecutors this and have them act on it. And if they don't, that's going to certify a defense.
This isn't the proper prosecutor. That's the Wayne County Prosecutor's Office on your other case, okay? This is the city attorney. Okay? Deputy, have a good rest of your day to you and your staff.
Thank you, Your Honor.
Thank you, Your Honor.
You see what I mean? Is standing there loudly insisting he doesn't recognize the court's authority. Yet somehow he expects the judge to treat him like he's guaranteed to stick around. He wants to reject the entire legal system one minute, then ask that same system to trust him enough to walk out the door for free the next. It's like he's trying to have it both ways, deny the court's power, but still benefit from it. And honestly, no judge is going to sign off on that. If you're openly claiming the court has no control over you, you're practically announcing that you won't show up if they release you.
This is the first time I have ever seen someone age an entire decade over just 3 weeks.
McMullen, case, the motion to set aside. Let me bring them out. People versus Martin, case 241388 SM. Today's the date and time set for a settlement conference. Also, there was a motion by Mr. Martin, motion to dismiss the case. Court has read through the motion. There was no accompanying brief in support. Well, there's also objections to the denial of the personal bond. I'm going to consider that as a motion for reconsideration. All right, Mr. Martin, was there anything else you wanted to place on the record, sir?
Oh, yes. Well, first, I'm not the fraudulently assumed defendant. I am a living sovereign man.
I can see that you are a living man. You are currently talking, and we are having a conversation. So, okay.
Right, but John, under the law, there's fraudulent presumptions under canon law 3228 that, that say otherwise, and there's a lot of support what I'm saying. That's why I say what I say to the record. But anyways, yes, I do have other things to say. First, I also want to file a demand to dismiss this case based on speedy trial violation under Michigan Court Rule 6.04C, 28 days for speedy trial in misdemeanor cases. I've been in jail over that since the 8th of last month.
This isn't Sunday service. Nobody's asking you to confess your sins. What the court needs is for you to take responsibility and actually cooperate with the pretrial process that includes completing the investigation so they can determine whether any jail time is appropriate and whether you even qualify for probation. Skipping that process won't magically protect you from consequences, if anything. Refusing to participate practically guarantees the opposite outcome and puts you on the fast track straight into custody.
And also, go ahead and do that. And I also want to say, I ask that you give me all the time to speak, say anything I want to say, instead of like shutting the court proceedings off that's happened before. Make sure I'm done with everything I have to say. But that's it for right now. But like I said, I might just say depending on what you say in response.
All right, well, your motion to dismiss is denied. Your motion for reconsideration with regard to personal bond is also denied. Are we setting this for a bench trial or a jury trial?
Well, I asked that question. I have to respond now to your denial. Now, based on what reasons are those denied, I have things to say in response to that.
Well, sir, I'm not cutting you off, but there's nothing. It's my ruling. If you want to file a motion for reconsideration as to anything, you're more than welcome to follow the court rule and do so. But there's really nothing to add to my ruling. I'm just
asking the reason. I'm not asking what are the reasons that the bond, for example, is denied? Okay, first of all, what reasons is it being denied?
I've already stated that last time, sir. So are we at the next question here is, do you want a bench trial or a jury trial?
Well, I have more to say in response to
do you want a bench trial or a jury trial, sir? Stop avoiding the question.
I just want to take off the jury.
Jury trial. All right, we're going to set this for a jury trial.
But I want to make it clear, I'm not consenting to
You'll be given notice of when that will be, sir.
Okay, I'm not consenting to the jurisdiction of the court still, and
Yeah, that's a terrible plan at the very least. A real attorney could stand up there and frame your bizarre arguments as the result of bad online advice, not as some deeply rooted belief system that only time behind bars could shake loose.
You are subject to the jurisdiction of this court, so you live in the state of Michigan, you live in the jurisdiction, and under the Michigan Constitution and the United States Constitution, this court does have jurisdiction over this case and over you as the alleged defendant. The warrant was signed with probable cause. The warrant had probable cause. The warrant was signed. That's all that's needed to bring a charge, and it's brought in the proper place, which is here because you live in Taylor, and this is Taylor, so this is where the case would be. So your motions were denied, and we're going to set this for a jury trial. We'll be giving you the date and time of when that jury trial will be. Let the deputy know that.
That's what I mean. See, I'm not done yet. I have more to say.
One way to get him to actually engage in his pretrial process, let him sit in jail earning 0 credit toward his charges until he fully accepts that a jury of his peers found him guilty, and it's time to own up to his actions. Fast forward to his second hearing, and it seems like he's starting to face reality, just not in